cover a couple of things with the lawyers. We appreciate your participating in this argument by a remote hearing. It enables the court to continue its work with the citizens of the state, all the people of this state, and it benefits them as well, of course, as your clients, be able to go ahead and do it. If we should have any technical problems, don't worry about it. We'll simply take a pause and proceed to work that out and then pick it back up. Call the case, please, Mr. Hibner.
Sharon K. Story et al. Versus Mark Stephen Meadows et al.
We'll hear from the appellant.
May it please the court, Robert L. Delaney for the plaintiff appellant Sharon Story, trustee of the Meadows Community Property Trust. May it please the court, this is an appeal from the trial court's dismissal as a matter of law of all the plaintiff appellant's claims based on a series of partial motions for summary judgment. Those claims were implied partnership, unjust enrichment, de facto merger, estoppel, constructive trust, and accounting. Additionally, the trial court granted the defendant appellant's motion to revise a previous chancellor's denial of their motion for summary judgment based on statute of limitations and latches. The standard of review, of course, on the summary judgment determinations is de novo with no presumption of correctness. The standard of review on the motion to revise is, of course, abuse of discretion. All of the summary judgment motions which were granted by the trial court on June 4, 2019 had previously been presented and denied by a predecessor chancellor reviewing the same law and facts, which was the basis for the trial court's June 4, 2019 decision. The predecessor chancellor had, of course, also denied the defendant appellant's motion for summary judgment based on latches and statute of limitations based on the same law and facts, which the trial court considered in making its June 4, 2019 decision on the motion to revise. Let me say to the court that the linchpin for the trial court's decision to dismiss all of the plaintiff appellant's claims on motions for partial summary judgment was its determination of the motion for partial summary judgment on the implied partnership claim. We are asking this court to consider whether the trial court properly applied the substantive law of Tennessee in its summary judgment determinations and whether it properly applied the state summary judgment standard as announced in Rye versus Women's Care Center of Memphis, TWB, Architects Inc. Versus the Braxton, and of course the older case of Bird versus Hall. As the court knows, to demonstrate the existence of an implied partnership, a plaintiff must demonstrate by clear and convincing evidence that under the totality of the circumstances, the parties combined their money, assets, labor, experience, and skill together in business and shared the profits. To make this determination, the courts in Tennessee look to the totality of the parties' conduct. It's not necessary for implied partners to intend to be partners or even know they are partners if their conduct evidences they are partners in fact. The fact that one partner claims sole ownership on business organizational documents or on a tax return is not sufficient under the implied partnership law of Tennessee to defeat a determination of implied partnership. The chancellor found in granting the motion for summary judgment on the implied partnership claim as follows. This is a quote from the court's opinion. Don Meadows did not contribute measurable value to Nashville Ready Mix in terms of time, energy, or resources sufficient to create an interest. Moreover, applying the equities to the situation, he took more than he gave and left those businesses and his wife owing Steve Meadows significant money through an inequitable distribution from Meadows Excavating and monies loaned to him from Nashville Ready Mix. The court also found that the testimony, deposition testimony of Messrs. Glasgow, Hunter, Gardner, Sawyer, and Marchetti regarding the supervision of Nashville Ready Mix's work and the combined circumstances of Meadows Excavating and Nashville Ready Mix was, quote, immaterial. Respectfully, we disagree with what the trial court found about that. I know you all have reviewed the record. I would suggest that it may be helpful to focus on the portion of the record about the formation of Nashville Ready Mix from 1987 to 1992-93, because it's clear that Don Meadows, during that period of time, made substantial economic contributions to Nashville Ready Mix, which assured its viability. And in fact, Steve Meadows, in his deposition testimony, said that all of the other plants, the other 9 plants that ultimately came into existence, were created as a consequence or from the success of that one plant. The
Mr.
record,
Delaney,
yes, sir.
Frank Clement here. How do we get past 2 what appear to be undisputed facts? And one is that your client was never listed on the tax returns of these entities. And number 2, the attorney who prepared all of the documentation for the various entities unequivocally stated that your clients were not part of the business.
Well, Your Honor, I think the answer to the question is that those things under the implied partnership law of Tennessee are not controlling. It's true that what you said is the case, but Pettis versus Yukon, Swacker versus Swecker, and other cases which the Court of Appeals has decided clearly said that those 2 factors are not the controlling things. The controlling matters, may it please the court, are the conduct of the parties. Did they combine their money, their skill, their resources, their efforts to make a profit and to share it? And if you look at the conduct of these parties as is reflected by the record in this case, that is absolutely what occurred here. So admittedly, Your Honor, those are matters which need to be taken into consideration. But of course, what happened here was the trial court found that there was not a measurable contribution made by Donald Meadows to this. And may it please the court, that's just not what the record reflects, or at least it's certainly disputed by the facts that we put forward in this matter. It's clear that in 1987.
Counsel, let me interrupt. I'm sorry. Before you move on, what did the record show as to what Mr. Meadows did as far as working at that first entity?
What it shows,
what I understand what you're saying about the financial contribution, but what did it show that he did as far as whether he worked there or not?
Well, it shows a great deal, Your Honor. And again, I would point the court's attention to 5 depositions. One would be David Glasgow's deposition, Britt Hunter's deposition, George Gardner's deposition, William Sawyer's deposition, and Gino Marchetti's deposition, which the court found the testimony that you're asking about was immaterial in the context of our summary judgment determination. And what those depositions show is that Donald Meadows was the inside guy. He was the guy who was totally responsible for the operations of Nashville Ready Mix and Meadows Excavating. He hired and fired. He was the fleet manager. He hired and fired drivers. He hired and fired mechanics. He had contact with all of the, of course, this was an evolving matter. Obviously, there were fewer in the beginning and more toward the end. But he had contact, the testimony is, every morning with every plant manager to find out what their needs were for sand and gravel, which Meadows Excavating trucks delivered to each of the plants as they developed. In the afternoon, he again had contact with all the plants to see what they needed for the next day and how much money, how much sales they had had in the course of the day. He ran the shop at 1326 Baptist World Center Drive, where the trucks, the equipment for Meadows Excavating and Nashville Ready Mix were serviced. There were mixed employees ultimately of Nashville Ready Mix and Meadows Excavating who worked out of that site. In addition to that, as the plants would be developed, Your Honor, Mr. Donald Meadows was the guy who did the site preparation. He would send Meadows Excavating employees out to do that preparation. Now, there's testimony that of course, in the beginning, when the Meadows Excavating fleet was used to deliver sand and gravel, there were haul bills back and forth. You will see references to that. No dispute about that. In 2002, there was a merger, we contend, of the two companies. All the drivers for Meadows Excavating and all of the trucks went over to Nashville Ready Mix. And although after that time, Meadows Excavating continued to file separate tax returns and that sort of thing, we contend that it really ceased to do business. It no longer had any equipment. Donald Meadows probably did some odd jobs with the equipment and used some of the equipment down on the farm. But as an ongoing entity, Meadows Excavating ceased to exist. Our position is, and we think the record reflects, as of, I believe it's February of 2002, maybe February 15, I don't remember the exact date. So that would be our position in terms of what he did.
Thank you, counsel. You have your time for rebuttal.
Yes, sir.
We'll hear from the appellee.
Good morning, everyone. I'm George Nolan of the Nashville Bar, and my co-counsel, Mr. Pat Flynn, and I are very grateful to represent the defendants, appellees, Steve Meadows, and the Nashville Ready Mix entities in this case. During my remarks, I will be discussing 3 independent alternative grounds upon which the trial court based its dismissal of the plaintiff's claims. And if the trial court was correct about any one of those 3 grounds, that sustains summary judgment and renders the other issues moot. Those 3 grounds are: first, the 6-year statute of limitations precludes plaintiff's claims. Second, TCA 61-1-202B, which is part of the Tennessee Revised Uniform Partnership Act, precludes plaintiff's claims. And third, based upon undisputed material facts, the trial court was correct in concluding that the plaintiffs failed to meet their burden by coming forward with clear and convincing evidence, creating a genuine issue as to whether Don Meadows had a so-called implied interest in Nashville Ready Mix Inc. Now, as the court knows, this litigation began when a father sued his son, claiming an interest in a concrete company known as Nashville Ready Mix. And that company is a thriving business that has operated for more than 30 years. And the father asserted that claim, even though during the history of this company, he never told his accountant, the IRS, or his own family, particularly his daughter, the plaintiff Sharon's story, that he owned part of the company. Now, the trial court based its ruling on several important undisputed material facts. During the long history of this company, the father, Don Meadows, through his accountant, created several personal financial statements that were provided to banks that listed his many assets, including his business holdings. But he never listed an interest in Nashville Ready Mix among his business holdings. As the court has already observed, during that same period of time, Don Meadows signed and filed with the IRS annually almost 3 decades of tax returns, and he never listed an ownership interest in Nashville Ready Mix on his tax returns. And his tax returns never reflected any profits of Nashville Ready Mix, and he never paid a dime of taxes on the profits of Nashville Ready Mix. It's undisputed that although Don Meadows did guarantee a handful of loans that benefited Nashville Ready Mix in the early years, those loans were short-lived. They were paid off within 2 or 3 years. The collateral was released, and Don Meadows never had to pay a single dime of Nashville Ready Mix debt.
Why does that matter? Why does it matter whether or not he ever had to pay anything on the loans he guaranteed?
Well, I think it matters, Your Honor, because it's reflected of the issue of whether Don Meadows ever contributed any particular value to the company.
Well, I assume the company wanted his or needed his guarantee for a reason.
Well, I
Wasn't
think
because
that's,
they thought it'd be a nice idea.
well, no, I think Your Honor's correct about that, but I think it's
So
important.
isn't that at least some value?
Well, not according to the plaintiff's expert, the forensic accountant, Mr. Rick Swafford. During his deposition, Your Honor, we asked him about this very same issue. And we asked him to tell us what the value is of the so-called credit enhancement that Don Meadows provided to Nashville Ready Mix in the early years. And he said, we don't know. We haven't calculated that. We haven't signed a number to that. In fact, the plaintiff's expert testified repeatedly during his deposition that they don't have any evidence about the value of anything that Don Meadows purportedly contributed to Nashville Ready Mix. So we drilled into that issue very aggressively, Your Honor, during their so-called damages expert. And he repeatedly testified that he couldn't assign any particular value to any contribution made by Don Meadows to Nashville Ready Mix.
Did he testify that he couldn't, or did he testify that he hadn't?
Well, he testified that he had not done that, and he had already disclosed his opinions thoroughly under the agreed scheduling order of the parties. And we had one opportunity to take his deposition. And when we took that deposition to ask him what his opinions were on that subject, he had no opinions on that subject and stated that he had not prepared any calculations in that regard. So it's our very respectful position that when a litigant comes forward and says, I have an implied interest in that business over there, but I don't have any evidence of the value of anything that I purportedly contributed to that business, then that litigant loses. And in our brief, Your Honor, on pages 55 through 57, we provided the court with a string cite of 9 Tennessee appellate decisions rendered in the implied partnership context that all make the point that contributions to a business are very important. But if a plaintiff doesn't offer any evidence as to the value of the contributions, then the trial court has no basis for awarding any particular percentage interest in the business. And so, very respectfully, the plaintiffs had failed completely to meet their burden on that particular issue. It's also undisputed that although Nashville Ready Mix has done hundreds of millions of dollars of business over the years, Don Meadows did not have check signing authority on a single Nashville Ready Mix bank account. And none of the corporate formation documents reflect that Don Meadows is an owner. And those documents were prepared by Don Meadows' lawyer.
Let me ask you about that, counsel. So, I understand your position you've made that look at all these documents prepared by Don Meadows' lawyer. Of course, it wasn't just Don Meadows' lawyer, was he?
He represented both Don Meadows and Steve Meadows on their separate business interests, yes.
Yeah. And I understand your argument that, well, look at all these corporate documents and whatnot that don't show that. But did you also object to that lawyer testifying?
That is right. We did object to him testifying.
So you wanted to use the documents that he prepared to show that, but yet you relied upon the privilege to keep him from testifying about it.
Let me explain the background on that, Your Honor.
Well, what's the answer to my question?
The answer is yes, we did.
Now explain it.
Yes. First of all, we never convened Mr. Marchetti's deposition. Our adversary convened his deposition twice. And Mr. Marchetti originally filed this lawsuit, and Chancellor Carol McCoy found that he was unethical in doing that. He violated rules 1.9 and 1.6 of the rules of professional conduct because he represented Steve Meadows and Nashville Ready Mix for a period of 17 years. And during that period of time, they paid him approximately $770,000 to do a lot of legal work, including forming the business entities and creating the corporate formation documents reflecting who owns this company. And then he turned around years later and he filed a lawsuit against his former clients, attempting to invalidate the very documents that he was paid to prepare. So the court found that he was disqualified and could not act as an advocate in this case. After that, Mr. Delaney became involved in the case, and he became very eager to use Mr. Marchetti as a witness. And with all due respect to Mr. Marchetti, my clients don't particularly trust him because he is a lawyer who turned on his clients and sued his clients. So we insisted that Mr. Marchetti follow the ethical rules if he provided any testimony. So we did not prevent him from testifying. He testified during 2 depositions, but there were hearings in the Chancery Court prior to those depositions. And in those hearings, Chancellor Young and then Chancellor Martin both concluded that the attorney-client privilege between my clients and Mr. Marchetti had been conclusively established, that he had ongoing ethical obligations to those former clients, and that he could testify, but he had to do so in accordance with the ethical rules, and he is encumbered by the attorney-client privilege. So my advocacy...
Counsel, let me ask you one more question on that, and then you might want to go to your other issues. Was there any determination of whether or not the lawyer was representing not just your clients, but that also was representing the father? So he had multiple, was representing multiple clients in those dealings.
His testimony, Your Honor, was that he represented Don Meadows and Steve Meadows on their various legal matters, and that Don Meadows was among Mr. Marchetti's clients when Mr. Marchetti prepared the corporate formation documents and all the other instruments showing that Steve Meadows owns Nashville Ready Mix Inc. I hope I've answered the court's question.
Yes, I'm sorry. And now I want to proceed to your other, I think you had 2 other issues.
Yes, the second ground for dismissal that I mentioned in my argument is the Tennessee Revised Uniform Partnership Act. And that statute says that when a business entity is organized under some other statute, such as the corporation statute or the LLC statute, it cannot be a partnership.
Well,
and
I'm sorry, exactly what does it say?
It says,
it's not
quote,
a partnership under this chapter.
That's right. It says an association formed under a statute other than this chapter, a predecessor statute, or a comparable statute of another jurisdiction is not a partnership under this chapter. And then the advisory comment indicates that the statute means exactly what it says, quote, business associations organized under other statutes are not partnerships. Those statutory associations include corporations, limited partnerships, and limited liability companies.
Is it your position then that statute, to the extent there is some other entity organized, has eliminated the law in Tennessee as to implied partnerships?
No, not at all, Your Honor. That's not our position at all. Our position is that, well, first of all, the Bass case, which was the Tennessee Supreme Court case that kind of gave birth to the line of cases about implied partnership, was a 1991 decision. This statute was passed in 2001. So it may represent a change in the law. However, when you look carefully at the implied partnership cases, they're not inconsistent with this statute. And I refer the court to the Bass case and the Montgomery case and the Swecker case and the Reed v. Thurman case, for example. And when you look at those cases, Your Honor, you find that Tennessee courts typically do not imply partnerships when parties go to the effort and expense of paying lawyers and paying accountants to carefully create business entities, carefully document who owns those business entities, and carefully allocate who should pay the profit of those on those entities for tax purposes. That's not the fact pattern in which courts imply partnerships. And if courts did imply partnerships in those situations, it would turn the law of business organizations in Tennessee completely on its head, because it would mean that business owners just can't rely on what they've paid their lawyers to do. They just can't rely on paying their lawyers to carefully create entity formation documents that reflect who owns the company. And if you look at the implied partnership case law in Tennessee, courts typically find an implied partnership when a man and a woman cohabitate together and run a business, but they never married, and then there's a falling out. And nothing like that happened here. And I see that my time is concluded. Thank you for your attention.
Thank you, counsel. We'll hear from the appellant in rebuttal.
Thank you, Your Honor. I'll start with the last point first. Implied partnership circumstances are not limited to domestic situations. We've cited to the court the N. Ray Carty case, which is a family case that Judge Payne in the bankruptcy court here in the Middle District decided some years ago. It's a situation very much like this case. Quadrosi versus Quadrosi is a New York case, of course, not binding on this court, but I believe that the authority is persuasive. Again, a family business circumstance. And of course, Dietz versus Keith, which we'll talk about in the context of the statute of limitations, is another case that is not a family case, but again, a circumstance very close to this where members of a business thought that they had an ownership interest despite the fact that no stock had ever been issued to them. And the court found in that case that there was an implied partnership following their termination by the holder of the stock. So it's just not correct to say that that implied partnership circumstances are limited to domestic circumstances between husband and wives or cohabitants. If the court adopts Mr. Nolan's interpretation of 61-1202B, then it will preclude courts of equity in Tennessee from creating remedies, as Chancellor Young found, to deal with the types of circumstances that are presented in this case. The record makes, switching gears here for a moment, the record in this case is replete with evidence of Don Meadows' contribution to Nashville Ready Mix. Steve Meadows had $9,000 in his bank account before his father made him a partner. They did that effectively, retroactively, I guess I should say, in 1996, but it was actually done in 1997, about the time that Nashville Ready Mix was getting ready to start. By virtue of giving Steve Meadows a half interest in Nashville, in Meadows Excavating, Steve Meadows ended up having a value there of $793,320, despite the fact that he didn't contribute a nickel to Meadows Excavating. His father also allowed him to take a draw out of Meadows Excavating in 1987 of $448,641. He gave him additional distributions. Don Meadows gave Steve Meadows an additional distribution in 1987 of $30,000. And then Meadows Excavating loaned Nashville Ready Mix another $10,000 for a total of $1,281,961 right at the time of the formation of Nashville Ready Mix, I believe on September the 1st, 1987. In addition to that, Don Meadows acquired a piece of property, 1326 Baptist World Center Drive, and Steve Meadows was given half of that. Meadows Excavating paid the note for the initial $520,000 that was loaned with respect to that. Meadows Excavating and Nashville Ready Mix did their operations out of that location from the beginning to the end, not totally, not exclusively. I don't mean to suggest that, but in terms of mechanical stuff, in terms of the fleet of trucks and equipment, that sort of thing. And then in addition to that, Don and Mary Helen Meadows guaranteed the commencement of operations for the first Nashville ready mix site over on Cowan Street in Nashville. And then in 92 and 93, they guaranteed the operation of Mount Juliet, the second plant, and Murfreesboro. And our expert,
Counsel, before your time runs out, I mean, but what are we to make of the fact that your client never reported, as I understand it, there's no dispute that your client never reported any of this income from the later companies on his tax returns?
well, that's true. I mean, he didn't like to pay taxes, and basically the way they had it set up was that about $3 million was distributed to Don Meadows and a little more to Steve Meadows from, I believe it's 1994 to 2013. I'm sorry, yeah, to 2013, and he didn't report it. But all of the income that
does the record show us whether or not Steve Meadows reported it on his tax returns?
He paid all of the tax that Steve Meadows owed over the years was paid by Nashville Ready Mix.
Well, does it show that he reported that income as tax?
I believe so.
I'm sorry, what'd you say?
I believe the answer is yes.
Okay.
But again, Nashville Ready Mix paid the tax.
All right, you've used your time.
Thank you.
Thanks to counsel for both sides. We appreciate your oral arguments this morning and your briefs. Mr. Hivner, if you'll recess court until 11 a.m. Central Time.
This honorable court is now in recess until 11 a.m.